You've overstepped your bounds, John. You've lied yet again. Which one of you guys approved it? Which one of you guys voted to get it clear-cutted? Did you know anything about it? It's already done. You want an amendment brought up to something that's already done? This sawmill company broke this contract because it was not approved. The amendment was not approved by the city council. And you guys sitting here like a bunch of bumps on a log ought to be ashamed of yourself.
My name is Adam Wentz with Linton News, and today we're going to be covering the most recent Linton City Council meeting, where there was quite the explosive array of accusations being made, all of it concerning the recent logging around the Buck Creek muzzleloader property, approximately 300 acres that are set to be clear-cut or already have been clear-cut in Linton, Indiana. So there's a lot to cover here, and there's a lot of complexities and legal nuances. I will add a disclaimer, I'm not an attorney. I'm just somebody who is looking deep into some of this information and giving you my perspective as to what I understand and what seems to be clear to me. So don't take this as legal advice. So without further ado, let's go ahead and go through that.
Next item on the agenda is an amendment to the Warner Timber contract based upon the DNR involvement with the project. The amendment was prepared for clear cutting.
The first place I need to stop is here, and I'll put it up on the screen. Back in August of 2025, following the tornado that came through the Greene County area, Greene County suffered significant damage, including this area that is set to be logged. There were a lot of trees that were damaged, and it did need to be handled. The city entered into a contract with Warner Sawmill to clear up the property. And this is a big point of contention. Even back in the August meeting, it was made very clear that the only thing that the sawmill was supposed to take care of were the damaged trees within that area. Damaged or old trees that needed to be cut down. And this language was explicit within the contract.
Any discussion?
I'd just like to reiterate that we are not logging out the whole Boy Scout camp, the muzzle loaders. It's just the damage from the tornado.
Just the damage from the tornado?
Yes.
Linda, the reason it's in the packet again is because I added some language clarifying that
Okay.
to what was originally presented.
Okay, I appreciate that. Thank you.
And as we can see from that clip here, not only the mayor, but also the attorney stated that only trees that were damaged from the tornado were going to be cut. And the attorney even stated that extra language was added as a protection to make sure that was, in fact, going to be the case.
I have a lot of questions about that. You want them now or you want to wait?
So moved.
Second motion.
Motion been made and seconded to approve the amendment to the Warner contract. Any discussion?
I have several things I'd like to discuss. I've got this for you guys. You'll pass one down. I've highlighted probably the most areas you need to know. This was a question I got an attorney to help me with. I hired an attorney to look into this.
So who's speaking there is Councilmember Linda Bedwell, who has done research on the contractual obligations of the city and the legalities surrounding the mayor going ahead and amending a contract without the approval of the city council. The issue for everybody that's not up to date is that the area's 300 acres, and I don't know how many of the 300 acres, but a very large quantity of the over 300 acres have essentially been clear cut. Well, this would have been contrary to the initial contract that the city signed and the council agreed to and voted on unanimously. Mayor John Preble took it upon himself to have an amended contract with the sawmill company after a DNR recommendation that if they clear cut the area, that the DNR had finances. There's a program essentially set up to where the city could take advantage of $20-30 million of improvement of this property with the assistance of DNR. Now, whether you're for or against the improvements or you would rather see the trees there, the issue surrounds the legalities of this. What Linda is getting ready to present from an attorney and what Indiana law does clearly state is that the mayor has no legal power to amend a contract that has been voted on by a city council. They could have had a session to come and vote on this as a council and approved it, but that did not happen. So we are now on July 13th of 2026, and an amendment was made on June 8th of 2026. And all the clear cutting appears to have been completed without the approval of the council. So what Linda is bringing up here is a protest to that amendment being made without following the legal process in the city council, the representatives of the citizens of Linton being able to vote on this.
In Indiana, for a Class 3 city where a contract has been adopted, approved by the Common Council, or signed by the mayor, can the mayor unilaterally extend the contract term, amend or change material contract terms without additional Common Council approval? The answer is, under Indiana law, a Class 3 city mayor cannot extend the term or amend material terms of tree removal contract that was approved by the Common Council without obtaining additional Common Council approval.
So you can see there, this is a commentary from an attorney that Linda has personally hired to look into this matter. And based on what that attorney is saying, he is stating that by Indiana law, the mayor has no authority to amend this contract, which he did, without the Common Council approval. And what they are trying to do now is to retroactively vote on something that has already happened. All of the trees have already been clear cut. So it's honestly kind of odd that you can even legally vote on something like this. I think this is very questionable from a legal standpoint. And my question is, what if the council votes no? We can't put back up thousands of trees, hundreds of acres that we've already clear cut. But I will continue.
On the second page, it talks about the mayor has no independent authority to negotiate, approve, or modify contract terms. When the Common Council passed a resolution approving the specific terms of the tree removal contract and the mayor signed it, the mayor's exclusive role was complete. I have talked to Pete Halstead, very nice gentleman. I worked with him probably for 30 years. I went out and talked to him and I asked him how this could happen. You know, how come everybody, the city council doesn't know about the clear cutting? That's not what we voted on. On the contract, we voted on, and in August of 2025, if you will look at the videotape at about the 6.8 mark, you and I had the conversation about damaged trees only, and you had changed the verbiage to make sure that that was in there, and the contract was approved on August 11th of 2025. After I'd heard several complaints from several individuals, I went out and talked to Pete, found out about an amendment, but I had no clue, never knew about amendment. The amendment was sent to John Preble on June 8th, the exact day that a person stood up here at a council meeting after the meeting was over and asked you several questions. And I can get a videotape of this. I have it if you need it. The person asked, they said, and this was the same day you received the amendment, I was curious about what was happening out on 1375 West, where the big trees were taken out on the city-owned property. You responded that the city-owned property was around the Boy Scout camp and damaged trees were being removed, and the area was pretty devastated. The person said a resident told me the trees were being taken out that were not tornado damage. All the trees were being taken out. You responded, no, they're not taking all the trees. You said that you had several discussions with DNR and the sawmill was taking down dead and damaged trees that should have been harvested long ago. Said the area even looked like a war zone. You said that they were taking trees only with the approval of the city. The city council didn't approve this. You sat and told that person falsehoods.
At that time,
You received, at that time, what do you mean? You received the amendment June 8th that Pete Halstead wrote.
he put it on my desk. I don't know what date that was.
It was June 8th.
Okay.
It was June 8th, the same day that you spoke to this person and told him you had no clue what was going on.
So what Linda is referencing right here is an individual that came up to the mayor after a meeting back in June, expressing concern that they were clear cutting the trees, not just removing damaged trees. And this was apparently on June 8th. She is subsequently saying here on June 8th, the mayor, by what record she is presenting, did have the amendment that would approve the clear cutting that Pete wrote up for the city. And this would indicate that the mayor did have some type of prior knowledge to this. Either he asked for this amendment to be made, because otherwise how would Pete know to write it? It wasn't pushed through or finished yet, and John is alleging that he hadn't seen it yet. It was on his desk, but he didn't receive it. This does draw questions, though, whether he received it or not. Who ordered Pete to write up an amendment that would allow for clear cutting? And since the mayor was the sole decision maker in this, that John would have had to know. That John would have had to know that clear cutting was the actual intended position. And Linda is alleging that because of that, he is lying to that citizen during that time. And John, it appears, is denying that he had full knowledge of the situation.
The way I understand it, the Warner people are good people.
Very reputable.
Very reputable. Well, then they should have figured out that you lied to them. You did not have the power to approve this amendment. And I'm probably pretty sure this amendment wouldn't even have been brought up if I hadn't have brought it to your attention.
It would have been brought up.
I really don't think it would.
What Linda's stating here is the logging company broke the contract because the mayor didn't have the authority to make the contract with them to begin with. And here at the end, John is saying, well, he would have brought it up. He didn't bring it up, so I don't understand what the logic is there personally, because he brought this up well after the fact, not before or during. It wasn't until after all the cutting had been done that this new amendment was made to their agreement.
It's already done. You want an amendment brought up to something that's already done? Answer, John.
Yes, because it was done verbally whenever that discussion
Verbally.
was.
Which
Would you listen?
one of you guys approved it? Which one of you guys voted to get it clear cutted? Did you know anything about it?
So here Linda is asking Mayor Preble, why we would vote on this amendment now after the fact. And he says he does want him to vote on it. He said that it was done, this amendment, this agreement with the logging company was done verbally, which that doesn't make any sense to me. The mayor doesn't have any ability to make a verbal contract with a logging company. And Linda is now looking to all the other council members, asking them if they voted on it. And obviously none of the council members have voted on this situation. So it's a bit of a redundant question. And she is stating, by law, this contract only could have been legal if the council voted for it or had knowledge of it in totality, and none of those things happened.
You guys out there, I answer to you. And you guys sitting here like a bunch of bumps on a log ought to be ashamed of yourself.
And here Linda is essentially calling out the rest of the council members, not saying anything about the lack of legal process that's happening here. Instead, they're pretty much just going with it. You'll essentially see that towards the end here.
You've overstepped your bounds, John. You've lied yet again.
Yet again, I have
Yes.
not lied.
I just want to ask something. Why are you doing a modification? The trees are down. They're clear cut. So now you're going to get the approval?
So this is another, honestly, this is a really good point and something that I have a lot of concerns and questions about myself. They're doing an amendment that states, and I'll go ahead and put up the amendment now and what it states. They're going to clear cut roughly 300 acres of trees, and not just storm damage trees. Obviously, not all of that is storm damage. And I think the cutting has already been done. It's already completed or mostly completed to my understanding. The amendment would give them the authority to do the cutting. So the problem that Linda is pointing out here is the work has already been done. So voting on it now is pointless, because whether they vote for it or not, the work that the contract would allow for them to vote on has already been completed. Therefore, that would make this whole situation illegal, as far as I understand
This sawmill company broke this contract because it was not approved. The amendment was not approved by the city council. Amendment was brought up June 8th The clear cutting started then. So now you're gonna vote on an amendment? If you guys are a day late and a dollar short, and you ought to all be ashamed of yourselves.
However we got it, was right or wrong, I don't know. But we're gonna end up with up to maybe 300 acres of ground that will be made into recreation products where the whole people of the town of Linton and other towns can use the property also. It's gonna be cleaned up.
So this is Tony Richards. He's sharing a little bit of his perspective. He is stating, regardless of what happened, the town is going to be able to utilize this 300 acres. It's going to be improved. It's going to be whatever, a park or, whatever the improvements that are going to be made there. It'll ultimately benefit the city, and that's his perspective on the situation.
The DNR is gonna come in and spend,
It's like 20 or 30 million.
yeah, they've got money they've gotta spend to get rid of right now.
I don't know about all the details of this DNR deal. I don't know if it's written in stone. I don't know if it's just a hypothetical or a potential. I'm skeptical. I know that there are grants and programs out there like this, and I hope that if this is going to be done, that we do get that deal, because it would be very sad if we didn't. That there's apparently $20 or $30 million that the DNR can use to improve upon this property. I don't know if it's the entire amount. I don't know if it's a partial amount. I don't know what type of improvements can be done with this. That's something they've not really given a lot of details about. Apparently, this is part of that amendment that they're speaking on. But I don't think that the amendment actually mentions anything about it.
You don't care that the mayor broke the law?
I'm not saying that, I'm telling what I want for that property, is what I want.
He went in and broke the law, and it's too late.
I'm not an attorney, and I can't answer that.
Well, I called an attorney, and if you'll take the time to read all this, it'll make you sick at your stomach.
So this is another, Linda is expressing that the problem is not necessarily that it's all been clear cut, it's been clear cut illegally is what she's proposing. And that's the part that Tony, Councilmember Richards, should be concerned with. He says he's not an attorney. That seems like a really weak excuse. I feel like you could just simply read and try to understand these things, especially as an elected official. Whatever.
And you said they were talking about clear cutting. I said, Eddie, are they clear cutting the damaged areas or the whole area? And your response was, well, I really don't know. Well, that is really sad that you didn't take the time to look into this. You're an elected official just like I am. Les is, and you guys don't care enough.
This is another conversation, and Ed Singleton, Councilmember Singleton, didn't really say too much here. I think he expressed that he was glad, at least that the property was going to be handled, and improved. She's referencing a phone call conversation, I believe, that they had where she alleges, and Ed doesn't dispute, that he didn't actually know how much cutting was going to be done, and she's claiming, that's bad that he didn't do any, actual research into how much was going to be done before looking into any of this.
Any other discussion?
I think there was a mistake made. I won't argue that one bit.
Thank you, Les.
But in the long run, I think we're gonna come out ahead.
That's Councilmember Les Newman. He seems to agree that this was wrong, that there was some mistake, but that's as far as it goes. He thinks that the project will ultimately be good for the city.
Yeah, I'm not gonna argue there wasn't a mistake made, because there was a mistake made. We should have known about it, but we didn't.
Time again, we didn't know anything about it.
Like I said, I think the city's gonna come out ahead.
So at the end of all this, we have a lot of questions about the legalities of this entire situation. At the end of the day, I guess the question lies with you, the residents. Are you happy about how this went? Are you happy that the trees were clear cut and that there's potential development going on? Are you not happy? Do you think the process should have happened differently? The question lies with you. What do you think as a citizen of Linton about how all this transpired? Was it right? Wrong? Let me know down in the comments below. My name's Adam Wentz with Linton News. Thank you all for watching.